Good evening, everybody. It's really with great joy and pleasure that Rui Cunha Foundation welcomes you all, distinguished guests, but and also, above all, distinguished speakers that we'd like to welcome. We are going to talk about ICC Court of Arbitration as connecting with the legal community of Macau as a major challenge and purpose. Welcome to Dr. Professor Ana Coimbra Trigo, which was the one to express the idea, and we would like to thank you so much for this initiative. And we would also like to welcome the distinguished guest, Miss Winnie Watt, coming from Hong Kong, but you will talk a little bit more about that. And obviously also Mariana Afonso Esteves and Fatima Dermoran, which will discuss and dialogue about this such interesting topic. Without further delay, I will give the floor to Trigo, and welcome you all for being here, and let's hope and we are sure that this is going to be a success for for this speaking. One of the presentations just arrived last minute. Welcome and excuse us for this slight delay, but I'm sure that everything will be okay, and this coming time will be of fantastic and excellent discussion topics. Thank you so much on behalf of Rui Cunha Foundation. The floor is yours.
Good afternoon, all. Welcome to this event. It's titled, as we just heard, ICC Court of Arbitration Connecting with the Legal Community of Macau. It is a pleasure to be here with you for the next hour or so in what is the first ICC event located in Macau. We are very happy to have in our panel a member of the ICC Secretariat, and also very, very happy with our host's great appreciation, Fundação Rui Cunha, represented here today, of course, by Tutor Rui Cunha, there at the back, but also by architect Francisco Ricard, who supported this project from the get-go. We are very, very, very thankful. Now, the purpose of the conference is twofold. So, as you may know, the International Court of Arbitration of the ICC is the world's leading arbitration institution. So, since 1923, it has been helping to resolve disputes in international commercial law and investment disputes. The court administers arbitrations by exercising judicial supervision of the arbitration proceedings, ensuring the proper application of the arbitration rules, and assisting parties and arbitrators. These efforts are supported by the court, the Secretariat, that's made of more than 100 lawyers all over the world, including right next to us here in Hong Kong. So this event will kick off with a panel where we will introduce to you all the workings of the ICC Court, including the role of the Secretariat, the role of the court, and provide an overview of the legal framework of arbitration in Macau and what motivates clients and parties to choose specific institutions. This will be roughly an hour. And we invite you all to stay after the panel and to directly communicate with us for a more social and informal moment and get to know the speakers, including Winnie in this case, who is coming from Hong Kong on purpose for this event. Without delay, it is my duty to introduce our panel very briefly. So to my right is Miss Winnie Watt. She's Deputy Counsel of the Secretariat of the ICC. She's credited as a Fellow of the Chartered Institute of Arbitrators in 2021 and a mediator of the Center for Dispute Resolution. Before joining the ICC, Ms. Watt was an international arbitration lawyer in a well-known international law firm, handling arbitration cases concerning aviation, construction, and international trade. She assisted in the research work of the Third-Party Funding for Arbitration Subcommittee of the Hong Kong Law Reform Commission. She's also a current member of the appeal panel of the Housing Bureau of Hong Kong SAR Government and was a member of the Jockey Club CPS Limited Advisory Committee for the overall management of the Tycoon, the revitalized historical Central Police Station compound in Hong Kong. Thank you for coming, Winnie.
Thank you for having me as well.
We have also with us Ms. Mariana Afonso Esteves, where she's a lawyer here at CNC Lawyers and Notaries, where she's been offering her expertise since 2009. Her practice areas encompass litigation, dispute resolution, mediation and arbitration, gaming law, insurance, probate, estate, and family law, as well as administrative and public law. She embarked on her legal career as a trainee lawyer at Oliveira Antunes e Costa Manso Associates from 2003 to 2005, and subsequently as an associate lawyer at Rui Cunha Glória Ribeiro and Associates until 2009. Mariana holds a Bachelor of Law degree from the University of Lisbon School of Law, and her professional affiliations include registration with the Macau Lawyers Association and the Portuguese Bar Association. She is proficient in Portuguese, English, and French. Thank you, Mariana, for joining us. Likewise, we have Fatima Dermoan from SANS China Limited. Fatima is a graduate of the Faculty of Law at Universidade Nova de Lisboa and a master's degree holder from Harvard Law School. She has been a practicing lawyer in Portugal since 2013, in Macau since 2016, and in the state of New York since 2020. Her professional journey commenced at a prominent law firm in Portugal, where she specialized in energy and international arbitration. In Macau, her primary areas of expertise include civil and criminal litigation and arbitration. She actively participates in dispute resolution processes, representing numerous national and international clients. Her responsibilities encompass negotiation, pre-litigation phases, as well as civil, criminal, and administrative legal proceedings and arbitration proceedings. Presently, Fatima holds the position of Assistant General Counsel at SANS China Limited, where she oversees the company's litigation department. Furthermore, Fatima has engaged as a lecturer in various postgraduate courses in the field of alternative dispute resolution and has as well served as speaker at various seminars and conferences. Her contributions include publications in arbitration in different law journals. Fatima, thank you for being with us. I will also introduce myself very briefly. Anna, I'm a senior associate at PLJ law firm. With 10 years experience, I regularly participate as counsel and tribunal secretary in international domestic arbitrations, including the ICC, Portuguese Commercial Arbitration Center, and ad hoc proceedings, as well as related court proceedings in civil and commercial litigation. I act in cases related to post-M&A matters, telecommunications, energy, aviation, and real estate. I'm a member of the ICC International Court of Arbitration, which I will speak a little bit more about in just a few minutes. And I'm a guest lecturer also at Nova School of Law, where I coach the Nova Vismu team, and I'm also an ICFML certified mediator. I'm Deputy Director of the Portuguese International Journal of Arbitration and Conciliation in Portugal, a member of the Diversity Commission of the Lisbon Center for Commercial Arbitration. I hold a very, very recently defended PhD in law from the Nova School of Law in Lisbon. I have a law degree from the University of Coimbra and a master's degree from the China EU School of Law, held at the China University of Political Science and Law in Beijing, awarded by the University of Hamburg. Having said that, we're going to kick off our panel with a presentation on the ICC, what we are here all to learn about. And so I quickly hand off the floor to Winnie. Yeah. Winnie, you have the floor.
Yeah. Thank you so much for inviting me, and thank you. So this is a very valuable opportunity, not just for us to share what I'm very passionate about is the ICC arbitration, but also to learn about the Macau legal community and how arbitration field in Macau is. That is something that is one of the purposes that we come here to learn more about the Macau community, as well as we see that there is a growth in Macau in arbitration. That is something that we have been looking at, and then we want to, this event will be the starting point, and then we hope to take us further from here. So thank you so much for coming, and then thank you so much for having the interest to learn more about the ICC, something I'm really happy and I'm really proud to share with you. And today my presentation will be arbitration proceedings under the ICC rules. So we will cover three main topics: is what is the ICC, what is an ICC arbitration, and what kind of dispute do we actually do. So what exactly is the ICC? ICC is composed of the ICC, the court, and the Secretariat itself. So ICC is a world business organization. We started after the First World War in 1919, by a handful of entrepreneurs which want to expand international trade, presents business all over the world. And one thing very special about us is the New York Convention that we use, that everybody uses in the world. In 1953, this is the first draft was drafted by the ICC, and then later it was modified in the UN and ultimately adopted. So ICC's mission today is still to promote international trade and investment as a vehicle for inclusive growth and prosperity. So we have the business side of ICC, and we also have the dispute resolution side of ICC. I must admit, more people will know more about our business side of the ICC, in which the intercom is actually one of our products of the business side of the ICC. So the intercom that we use in contracts is actually from ICC. We also have policy advocacy in WTO and UN as well. And for the dispute resolution side, we do arbitration as well as ADR, including mediation and expert rules. So we have quite a few sets of rules. The main ones that we'll talk about is the arbitration rules. And then, but also we have a dedicated team handling all the other ADR services, including the mediation, the expert rules, the dispute board rules, and the docs rules. So the ICC consists of 4 main organs, which is the ICC Court of Arbitration, which we are very honored to have Anna to be on our court and then to help us with all the court work. It's a lot of workload, and then she's doing it for free. And
No complaints. No complaints.
and she will explain a little bit more about the ICC court, how ICC Court of Arbitration works, and then her workload at the ICC Court of Arbitration. And the court actually consists of 1 president, which is Claudia, which will be in Hong Kong from Tuesday onwards, from Tuesday and Friday. And then 70 vice presidents, and then 195 members worldwide, which has an expertise in arbitration. And then they will meet on weekly basis for court sessions, and then bi-monthly special committee sessions. So what's the difference between the two is that usually regular procedural directions, we will ask the court to consider it weekly. But then for very special ones, such as any challenges challenges of arbitrators, those special and sensitive issues, we will put it in a special committee where there will be around, each time the attendance is different, but then it will usually be around 20 members discussing all these issues. So we also have the court, the secretariat, where I am, and then we consist of 12 case management teams. And one thing very special about ICC the ICC secretariat is there are more than 50 of us are lawyers. So, for example, for the Hong Kong office, our counsel is qualified in mainland, while I'm qualified in Hong Kong, and then my other deputy counsel is qualified in US. So we actually covered different jurisdiction as well. And then we have a lot of diverse nationalities, and then we speak all of us speak different languages. For the Hong Kong office, we can cover English and Mandarin and Cantonese, that's a basic. But then what is surprising is we also covered Japanese and Korean as well. And then what is special about ICC is if the parties agreed to a language, for example, they agreed to Thai, they can actually communicate with us with Thai. How we do it is we have our internal translator, which support the service. So they can communicate freely or in a language that they agreed to and comfortable with. So that is one of the main support that ICC will provide to the parties. And then we also have the ICC International Center of ADR, which deals with mediation cases and then expert rules. It's a different set of rules. We have one dedicated team in Paris responsible for doing all the mediation and expert rules matters. We also have the legislative body, which is the ICC Commission on Arbitration and ADR, which is responsible for drafting dispute resolution rules. For example, they will look out for policies in which they can actually push in their own jurisdiction, try to let arbitration grow in their own jurisdiction, or something which is ongoing, which is the review of the rules itself, review of the ICC rules itself. So this commission is responsible for the legislative part of the ICC, and it consists of more than 700 members worldwide. So I just mentioned there are more than 190 court members. This is just part of it, and then I have circled some of the main ones in Asia, which is we have one vice president from China, and then we have several members from China, Hong Kong, and also Anna from Macau. So as I mentioned, there are 12 teams of the Secretariat. We cover different regions. 7 of them are in Paris, and then they cover different regions and different languages. There is 2 Asia office, which is the Hong Kong office, as well as Singapore office. The Hong Kong office covers the Northern Asian part of the region, and the definition is actually very wide. So it goes all the way to Qatar. So we do have cases from Qatar, and then it went down to Indonesia and India as well. We also have cases from these regions as well. And then obviously we have Singapore, and Singapore also covers, we share pretty much the workload with Singapore as well. So arbitration proceedings under the ICC rules. In ICC, we have a standard ICC clause. The parties have to agree to ICC arbitration in order to submit their arbitration to ICC. But then we also have some suggestions on what to put in an arbitration clause in addition to the standard clause. This will make our life, the party's life, and the lawyer's life much easier. So what are these suggestions? These are the place of arbitration, where the seat of arbitration is. And then this will actually dictate the procedural law, which actually oversees the entire arbitration. And the number of arbitrators, in which whether the parties want 3 or 1. This will highly related to, for lawyers, this will be highly related to cost of arbitration, but also, very importantly, to attract different talents, to enlarge the talent pool of the arbitrators. So they may have different backgrounds or different expertise. You can, for 3 members, they can actually have different expertise on the same panel to consider, to give a more global view of the entire arbitration. The language of arbitration, as I mentioned, we don't have an official language in ICC. Although in the first instance, we will communicate in English, because that is only, that is, but then we have Chinese cases, and then if the parties agree, especially in Chinese, if the parties agree to Chinese, we will act, for the Hong Kong team, we can administer, and we do administer the case entirely in Chinese as well. And then also the applicable law, which governs the interpretation of the contract if it's a contractual dispute. So what does a standard ICC arbitration case actually looks like? There has been some blocks which is highlighted in purple. That is the active, that's the part where the ICC Secretariat and the courts actually are heavily involved. You can see that it's mainly the beginning part of the arbitration as well as the end part of the arbitration that we're very involved in the arbitration. So to start the arbitration, we need the request for arbitration, and then the other side will submit an answer in response to the request for arbitration. And then for some procedural issues before the tribunal actually are constituted, those ones we will decide, it is really the work of the Secretariat and the court to decide on these. These issues include joinder, whether a party can join into the arbitration, and where there is a multiple arbitration clause, how we are going to deal with them. And then also prima facie jurisdiction for a very obvious case where there is or where there isn't jurisdiction. Sometimes the Secretary General will refer it to the court to have a closer look before it proceeds to the entire arbitration. So for prima facie jurisdiction, the court will actually share the workload, and then we'll actually have a closer look based on their expertise and to see if there's really a jurisdiction, if there's really ICC has the jurisdiction to decide on the case. And also place of arbitration when the parties haven't agreed to. That is something for the court to decide as well. And then also at the very beginning of the stage, fixing the balance on costs and also constitution of the tribunal, which includes deciding on the number of arbitrators. If that is based on if the parties haven't agreed to any of these. If the parties have agreed to them in arbitration agreements or subsequent correspondence, then it's really up to the parties to decide. But then if the parties are going against each other and then can't agree to this, the Secretariat and with the court, with the help of the Secretariat, will decide on these matters. So the very heavy workload is basically at the beginning of the arbitration, where the tribunal hasn't been constituted. So when all these are decided, we will pass the file to the arbitrator and for them to handle their case. One thing very special about ICC arbitration is we have something called the terms of reference. This is actually the first piece of homework for the arbitrator. This is also for us to assess the arbitrator as well, how much support the arbitrator actually needs for the arbitration. Because with ICC arbitration, the Secretariat is actually very hands-on. So if the tribunal needs more support, we will actually give a very close eye on it. And then by saying more support, we actually, for all the parties who sent in the correspondence, for the arbitral tribunal who sent in the correspondence to ICC, the case manager will actually read every single one of them. And that if we spot any obvious red flags, we will flag it to the tribunal. Although the parties won't see it in the correspondence, that is something what's happening in the background. Very obvious issues such as confidentiality and without prejudice. Some of these issues doesn't appear in each jurisdiction, and then some jurisdiction doesn't have this concept at all. So if we see that, and then if we see that the tribunal may not know this, we will flag it to the tribunal. It's up to the tribunal how they want to deal with the case, because ultimately they will be responsible for the enforcement, and then if there's anything happens to set aside, it's really up to them. But then it's really our responsibility to flag it to them. So. And after the terms of reference, we have the case will be handled by the arbitral tribunal, and then afterwards it will be where the court will step in again for the scrutiny of the award, which Anna will talk more about in later of the presentation. Okay, some of the common questions of what will happen if a party fails to nominate an arbitrator. That is actually more often than usual that will happen Usually when a respondent doesn't respond, there is no chance for both parties to nominate an arbitrator. So what will happen in these cases? So there is three main ways of nominating an arbitrator in ICC arbitration. First, it's nominated by parties. Everybody knows how it works. So the parties nominate it. And then second, it's by the national committee. When the parties cannot agree to a candidate, it's for the national committee to nominate one. The national committee consists of arbitrator expertise in that region, and they will nominate someone for the arbitrator case based on the case nature as well as the size of arbitration. And then also for cases involving SOEs, court interests, state interests, as well as very political sensitive issues, we will have something called direct appointments, which we will directly pick a few arbitrators, ask them for the forms, ask them for information, their CV as well, and then to present to the court, and then to make a recommendation to the court for them to decide who is ultimately more suitable for these kind of cases. So another common question is, does ICC have a list of panel members? The answer is no. The ICC does not have a list of panel members. This actually is a very flexible approach where we are not limited by any list to our appointment. So this is very beneficial for the first-time appointee as well. We're not limited by any list. So we are free to appoint anyone in different jurisdictions as long as they're suitable for this case. And then ICC arbitration is very suitable for first-time appointee as well, because we have the support from the Secretariat, because the Secretariat will look at the case very closely and will be able to provide support to the arbitrators when we see it, obviously red flag, and then to assist them on the procedure-wise, on the administrative side of the ICC rules. So it actually gives the first-time appointees a very good opportunity to run the arbitration with the help of the ICC arbitration, with the ICC Secretariat, and then also with the scrutiny of those awards as well. But even though if we don't have ICC lists, you can also search online which arbitrator actually has an ongoing or a closed case with the ICC. So this is more for the parties and more for the lawyers. If they want to appoint an arbitrator and then they don't have any idea which arbitrator has these kind of experience, ICC experience, as well as the experience with this industry, then they can go to online directories and search for the arbitrators who is handling the case. The case will be, you won't know the details of the case, you will only know the name of the arbitrator and the industry of which the case is relevant to. So some statistics, because I've mentioned a few ways of how the tribunal is appointed. So around 11% is directly appointed by the courts in 2023, and then national committee is 16%, and the nomination by parties is still the majority, it's 57%. And then you can see that there is a diversity, and the diversity is something that we focus a lot on. Not only on gender is something we focus on as well, but also on the nationality as well, because we want to get different people from different jurisdictions as well. So according to the 2023 statistics, we have arbitrators from 98 jurisdictions. So some of the main features, I will touch this a little bit, and then Anna will explain more on this. We have one very special features of ICC arbitration is scrutiny of the awards. This is to maximize the legal effectiveness and identify the defects, and then general accuracy and quality and persuasiveness to improve them in the entire awards. So what will happen in a scrutiny of awards, this is something special about the ICC, is there is 3 levels of scrutiny. So there will be at least 3 person, at least 3 person looking at your awards, and they need to all approve this award in order for the award to be approved. The first level is done by the team level. For example, if your case is managed by the Hong Kong office, it will be done by the counsel or deputy counsel or the office which handles the case every day. So they will understand the case, and then they can actually go as deep as going into the submissions of the case to understand if there's any missing arguments that the tribunal hasn't addressed. And then they will also understand the procedure of the case, so to make sure that the procedural history includes everything in because it's very important for the enforcement to show that there is procedural fairness to the parties as well. So the first level is done by the Secretariat, the team level, and then the second level is reviewed by the Paris management. So they will look at a more global view on enforcement, on different enforcement risk, and flag it. And the last level is the court scrutiny. It will go to our court members, where we can utilize the strength and the expertise of our court members to scrutinize the award. So what will happen is it will either approve subject to comments, where the court members and the team will give them comments, in which case they will go back to the tribunal and the tribunal will revise the award, or approve the award, where the tribunal will sign the award and send it to the Secretariat to notify the parties, or they're not approved and sent back to the tribunal. And then what will happen if a case is not, if an award is not approved, is that they will send us a revised version, and the entire process will start again. So it will go through the 3 levels again, and then the court will decide whether to approve it or not. Another very special feature about ICC arbitration is the timely submission of a draft award. So there is a time limit for the arbitrator to submit the draft award to us. This is 3 months. 3 months if it's a 3-member tribunal, or 2 months if it's a sole arbitrator. So their fees, their arbitrator fees, which is ultimately fixed after their awards is approved, is correlated to the timely submissions of the award. So if they submit it late, what will happen is, according to our notes, we have the power, the court has the power to reduce their fees. And of course, if they have run the arbitration expedite very quickly, and then the court has the discretion to increase the arbitrator's fees as well. And then, so regarding the reduction, there is some guidelines in our notes on how much they're gonna lose. If there's a delay up to 7 months, it will be a reduction of 5% to 10%. If there's a delay of 10 months, there will be a 10% to 20%. That's actually a very substantive sum. And if it's more than 10 months, it can possibly attract more than 20% of the reduction. But of course, when the court decides on fixing the cost, they will look at the arbitration in a holistic view. And also, they will look at if there's any factors which is outside the arbitrator's control that they cannot control, and that they will consider this in fixing the cost.
Health reasons, for example, is one of the common ones. Yeah.
And then also very special, the third special features of ICC arbitration is is the expedited proceedings and the emergency arbitration. Expedited proceedings is for small amounts and disputes proceedings. It's a faster procedure, and it's also a cheaper procedure, where the arbitrator fees and the ICC administrative fees will be on a different scale, and it will be a cheaper scale. And these are for the cases under $3 million US, and normally it will be administered by a sole arbitrator, and there's no terms of reference, there's only a CMC. And the arbitrator is required to submit the award within 5 months, and then we issued it within 6 months. So it's a quicker proceedings for the parties to resolve a smaller amount of disputes. Also, the emergency arbitration for parties to get their interim measures, the procedural order for the emergency arbitrator will be generated within 15 days after the tribunal has been constituted. So what kind of disputes ICC actually do? This is the statistics of the new cases that we have for each year. This, for 2023, we see a very big surge, a rebound. Previous years, we have been affected by COVID, and we see a very big rebound. For 2023, there is 870 new cases with the ICC. And then, according to 2023 statistics, most of the cases are related to energy and construction and engineering. There are other cases as well involving different sectors, food industry, pharmaceutical, metals, financing. And then the amount in disputes in the pending case, and we have most cases within the 10 million to the 30 million range, and the second most is within the first, within 1 to 5 million amounts in disputes. And then we also see that there are other small cases as well. There has been a growth in the EPP cases, the expedited proceeding cases, and then you can see that there has been at least like 400 cases within this amount. So that is all for my sharing.
Thank you, Winnie. So that was a lot of information, but hopefully it tackles most of the questions and doubts that you may have. I'm going to now step in and speak a little bit more about the ICC Court that Winnie has mentioned several times, just to go into a little bit more of the detail of what I believe is the strongest added value feature of the ICC, which is this hands-on approach, including the work of the Court of Arbitration. So if we could now switch to the second PowerPoint, and then we can go from there. In the meantime, I will very quick. Okay. And so we can start. So I'm going to give you, trying to not repeat myself in what Winnie has said, complement her presentation. So basically, the ICC Court is an administrative body that ensures the ICC arbitrations are conducted in accordance with the rules. While the name is that of a court, it is not a judicial body in the traditional sense, because we may name state courts or national courts. It's not a court in that sense. It's an administrative body that makes certain decisions about ICC arbitrations. And so you see here, the rules are very clear. We have the necessary powers for that purpose, and it is an autonomous body within the ICC, meaning the deliberations are of the court and of the court alone. Its composition was already discussed. We have the president, Claudia Solomon, the first president of the ICC Court in its history, 100-year-old history. The president is elected upon recommendation. You have the bureau, which technically is a name for the president and the vice presidents of the ICC Court. We have 19 vice presidents that were already all listed here earlier. And you have members and alternate members. So for some countries, you'll have two members, a member and an alternate member. I say countries, but we should more appropriately use jurisdictions in the case of Macau and Hong Kong, for example. And so all the members participate in committees and special committees. They're appointed either by proposal of ICC national committees, or where there is no national committee, as I believe is the case with Macau, directly from the ICC president, which was my case. And you may also have observers. So it is not uncommon in our sessions, which are confidential, that certain ICC clients, so the parties directly, are invited, of course, under strict confidentiality provisions, to observe the work of the court and witness this value add that the court adds. The appointments are later confirmed, and all the members of the court serve for a 3-year term that's renewable once. So I was appointed the summer of last year, so I'm currently almost finishing the first year of my term, and I have 2 more years to go. The court is, of course, assisted by the wonderful work of the Secretariat. Nothing we do comes from a blank slate, so all information we receive on all the cases is prepared by the Secretariat. So what are the types of sessions we make? So you have weekly sessions, Winnie has mentioned, 3 court members, very routine decisions, so it includes a lot of the things that you've heard already, fixing the costs, confirming appointments, things that are non-controversial and fairly easy to decide on. Then you also have special committees. These tend to challenge to deal with more sensitive issues. So I have here at the last bullet point, you'll see challenges of arbitrators. They're very difficult decisions sometimes. Sometimes they're very easy. It depends on the case. Some arguments are easier to make than others. But for example, whenever an award has a dissenting opinion, that those are some of the awards we look at. So we look at the majority award and we look at the dissenting opinion. Of course, also when involving states or SOE entities that involves more particular issues, but also where there are replacements of arbitrators. For example, if there's a casualty, the arbitrator can no longer continue the case. That replacement is also something that we decide. And this is a special committee because it requires a stronger quorum. So not only 3 members, I think the rules provide for at least 6 members, but typically we are 20 plus in each of the meetings, which means that all 20 people have to read the case file. We have to read the agenda. We have to be aware of the details of the case before we make a decision. You have single-member committees as well. For example, the expedited procedures that Winnie just explained. So the quick procedures that can have to be done in a shorter time. The award comes in 6 months with a sole arbitrator. That is normally also assessed by a single-member committee. So 1 member will assess that award, for example. And then every year there's an annual working session, I think in November in Paris, that we'll be happy to attend. So how do we prepare? I've already explained, our work is strictly confidential. We cannot make public the decisions we take in the cases we address. We run a simplified conflicts check. That means if every year we receive a newsletter from the ICC with all the new cases, if I spot parties that I know me or my firm is involved with, I will check them, and that means I will no longer have access to any detail on the case that involves those parties. We receive court binders in preparation of these sessions that are very kindly and helpfully prepared by the ICC. And then for each case, especially in the special committees case, so remember those cases that are sensitive with state entity sensitivities or defaulting parties or dissenting opinions, in those cases, each case will be assigned a reporter. So the reporter is in charge of making a recommendation to the court, to the group. So each case is presented by that reporter, who will issue a written formal recommendation, and then that recommendation in the case is discussed within the whole meeting, which adds a layer of increased scrutiny for each decision we make. We have to be prepared. We are required to read all the case file. For example, I have a meeting now this Thursday, and we have 6 cases. So that means I will be reading the agendas on all 6 cases. I think we have a challenge, and the other ones are awards revisions. So we have to be prepared. We are expected to be prepared. And most of our work takes place in hybrid format, and there's very, very active participation. I think truly one of the biggest added values, as you can imagine, is there are members from all over the world. So most of the jurisdictions are represented in these discussions, which means that if there is a case between a Chinese party and a Brazilian party that is seated in the UK, in London, I mean, we will have in the room members and lawyers from all these jurisdictions who are happy to step in case there's an issue that is flagged that concerns those jurisdictions. For example, I had a recent case, just as a matter of example, where we were discussing a pathological clause. So, for example, a clause that stated that the arbitral tribunal was to be constituted by 3 arbitrators, all appointed by one party, the claimant. And so, of course, there was a big discussion because there are some jurisdictions that do not accept this kind of uneven, unequal arbitration clause. And so having in the room, when we make these decisions, lawyers that are from those jurisdictions where potentially you will enforce the award or where potentially the enforce could be annulled, adds a lot to the discussion and informs the decisions of the courts. So you basically have a pool of worldwide expertise with us. So what types of court decisions do we make? Exactly as Winnie mentioned, first submission, so prima facie jurisdiction. One of the examples that I have is, for example, when you have multi-contract dispute. For example, you have a shareholders agreement or an SPA, and not all the parties are coincidental, for example, or you have an example of a parent company that did not sign the agreement, but the lawyer intervened, and there's a discussion of whether or not that non-signatory could be bound by the arbitration agreement, even though they did not sign the contract, but they were negotiating, executing it, etc. Those kinds of decisions fall within this category. Fixing the place of arbitration if the parties have not done it, and also constituting arbitration tribunals. Of course, appointment of arbitrators. The parties nominate the arbitrators. The arbitrators have to run a conflict check. They have to file to disclose their availability. So ICC really has good practices here in place, but that does not equate to an immediate appointment. So the court will still review all the information that it receives before appointing the arbitrators. The terms of reference, this unique ICC characteristic, this document that compiles the most important information of the case, is also approved by the ICC court, so it has that scrutiny as well. Time limits. Every time an arbitrator asks for more time to render the award, the court will approve. So that as well is a decision that falls within the scope of the court. Challenge, resignation, and replacement as arbitrators, as mentioned. Any fixing or readjustment on advance on costs and other financial issues. This is incredibly important and quite discussed and strictly enforced, actually. So this characteristic mentioned on the possibility of reduction of fees in case the arbitrator is delayed, I can tell you is strictly enforced. So the ICC has a very, very strong policy there of making sure arbitration runs on time. And I would say that's a distinction because, for example, if you compare it with ad hoc arbitrations where there is no secretary, no institution administering the arbitration, it really falls on the arbitrators, right? Whereas here with ICC, you have someone you can call, like Queenie, and you can ask about the case, and really everyone in the process is accountable for the decisions that they take, including, of course, these financial decisions on readjustment. There are also reimbursements in case not all the fees that were advanced are used. So all these decisions are run and are made by the ICC court. And of course, the bulk of the work, so the most important part of the work, is awards. So that includes final awards, partial awards, awards by consent, any addenda decisions, and any additional awards, including awards on costs, for example. Any withdrawals, any reconsideration agendas, these are more smaller items. as well as special procedures, including expedited arbitration and appointing authority rules. So it's quite a broad spectrum of issues that we need to discuss. A few words on scrutiny. So of course, scrutiny is designed to enhance the quality and enforceability of awards. So the idea is that the award has to pass these several multi-layered step process in order to be finally notified to the parties. And all this process happens behind the curtains, behind the scenes. So the parties do not have access to the discussions that happened before. They're only made aware of the award once the award is notified to the parties. And so what does the court do? So when I meet with my colleagues of the court, what exactly do we look for in the arbitration awards? There's an ICC award checklist that has a few issues that have to be in every ICC award. It includes things as basic as the correct name of the parties, the seat, any details that relate to the arbitration proceedings, any reference to specific contract provisions, law or evidence. For example, there's a paragraph with a decision pointing to termination of the contract, but the article of the applicable law in specific was not identified. Then the court can suggest, because all we can do are suggestions, we can suggest that the arbitral tribunal consider identifying or being more specific in identifying the applicable law. We're especially careful when it comes to non-participating parties, so we have to make sure that the award reflects the efforts that were made in terms of notification. Why? It's a due process issue. It's a topic close to my heart, where I've dedicated a lot of time for research. But basically, the award has to reflect those efforts, that the attempts at notification of the party were made, how they were made, how often they were made. All of that has to be a part of the award. Another issue that is also flagged normally has to do with jura novit arbiter, jura novit curiae, so the fact that the principle that the judge knows its own law. Not every jurisdiction accepts this principle equally in arbitration, so there are different national approaches. And so if the arbitrator or the arbitrators want to decide based on a legal solution that was not argued by the parties, that is also an issue that we normally flag, so that the arbitrator can ensure that this was discussed or not, clarify if under the applicable rules this could or could not be a problem. Dissenting opinions are also one of the issues we address, so to make sure that the majority award reflects all the points raised by the minority award. Any issues on fraud, illegality, allegations. When it comes to awards by consent, so awards that the parties submit for the ICC for approval, what exactly, making sure that they align with applicable mandatory requirements, making sure that they write an enforceable dispositive section. It may seem very obvious, but it happens a lot of times, especially if parties adapt their request for relief during the proceedings. If they add or subtract any kind of requests, making sure that the final dispositive section of the award deals with all the requests made by the parties to avoid any infra or ultra petita assessment later on. Of course, being rigorous about costs and also about interest. If interest is an issue that is stable in a lot of jurisdictions, in other jurisdictions it is not. In Brazil, there are different rules that are applied to different jurisdictions. Angola also has different rules. So it is often an issue that is overlooked or perhaps not addressed in as much detail as it should be. So these are some of the examples of the things that we look at when we scrutinize awards. I think that's it for me on my end. And I think I now give the floor to Mariana to talk a little bit. And we're going to transition here a little bit into a Macau-focused discussion very briefly, yes. And then we will continue. Mariana, you have the floor.
Thank you, Anna. Good evening, all. First of all, thank you for the invitation of the Rui Cunha Foundation. It's a pleasure to be seated here with these talented and dynamic young ladies. Thank you. After this beautiful presentation of ICC Court, which is the reason I believe we all came here tonight, I was asked to say a few words about Macau arbitration landscape. Well, as you all know, arbitration in Macau is regulated by law 2019, which is in force since May 2020. So a very recent piece of law. And this law was adopted pursuant to the intention of Macau government to promote Macau as the center for resolving commercial disputes between China and Portuguese-speaking countries given the great potential that Macau has to contribute to the resolution of such disputes more quickly and effectively, thanks to its large pool of bilingual professionals such as lawyers, arbitrators, experts, and the similarity between the legal system and the culture between Macau and the Portuguese-speaking countries. So it was necessary to provide Macau with a modern law and a legal framework to ensure that all players, domestic and international, the safety to choose Macau as the seat of their arbitration disputes, reason why our law follows the UNCITRAL model law. Of course, with minor differences, but the basic principles and rules were adopted in this law. Also, there was a need to harmonize our internal legislation because before this new law, domestic and international arbitration were regulated by two different pieces of legislation. There was also some gaps that needed to be filled in respect mainly to interim and preliminary measures, recognition and enforcement of arbitral decisions. And also it was necessary to integrate the alterations that were introduced in 2006 to the UNCITRAL model law. Apart from this legal piece of this law, Macau also has other conditions that I think it needs to be mentioned. Macau is part of the New York Convention for Recognition and Enforcement of Foreign Arbitral Decisions, which contributes for the security and certainty when it comes to the need for the recognition and enforcement of arbitral local decisions outside Macau and vice versa. Macau also has bilateral agreements with mainland China and Hong Kong, which facilitates the recognition and enforcement of the arbitral decisions in these territories. Also, the judicial courts in Macau are very cooperative in terms of arbitration matters, which includes, for example, granting injunctions within pending or imminent arbitration proceedings, appointing arbitrators, obtaining evidences, enforcing arbitral awards. So, in short, Macau has the legal framework for arbitration that can ensure security and confidence for national and international parties in choosing Macau as the seat of their arbitration disputes. In terms of infrastructures, and I'm focusing on commercial arbitration, Macau has two arbitration centers. The World Trade Center Arbitration Center, which is in full function. It has a list of 67 arbitrators and 17 mediators. It has handled around 1,250 cases, being 80% of these cases related with water infiltration disputes, 17% lease agreement disputes, and the remaining 3% other disputes, in which I believe we can include the commercial disputes, either domestic and international. The rules of the center and the costs are in line with other centers in other jurisdictions. We also have the Lawyers Association Arbitration Center, which is now being restructured, and I hope that is soon fully operational. And according with the available information in the AAM website, the rules and costs are also very simple and in line with other centers in other jurisdictions. We also have ad hoc arbitration. I don't have much to share about this. I don't have any numbers, but I do believe that the cases for ad hoc arbitration are even lower than the cases pending on the institutionalized and in the centers. So, in conclusion, Macau is equipped with a modern and secure legal framework, a system that can guarantee security that any player seeks. However, in terms of promotion and infrastructures, I believe there is room for improvement. Despite we hear more and more about the advantages of commercial arbitration, whether in terms of speed, less complexity, specialization of the arbitrations, confidentiality, etc., there is not a great deal of given evidences to instill confidence on the players to choose arbitration and also to choose Macau as the seat of their arbitration cases. In most clauses inserted in arbitration contracts I have contact with, even if the parties are Macau local companies, the place they choose for the seat of the arbitration is usually Hong Kong, right? So what can be done to revert this or to help to promote Macau? I have some personal opinions I will share with you, but I believe that the answer is within the local legal community, and also I think the government can also help to promote the arbitration in Macau. I think we lawyers, we must advise our clients on the benefits of arbitration, help them drafting arbitration clauses, and guide them to choose Macau as the seat of their arbitration. Local arbitrators need to keep pace with recent developments and specialize themselves in specific areas in order to guarantee the quality of the decisions and efficiency of the arbitral procedures. And the arbitration centers operating in Macau must keep up to date and follow international trends. They need to be equipped with experienced staff and provide services with high level of quality and efficiency. And regarding Macau government, we all are assisting that Macau government is encouraging enterprises registered, namely in the Greater Bay Area region, to choose Macau as a place of their arbitration, which is a great opportunity for Macau arbitration business to be expanded. Not to mention also the intention to promote Macau as the center of the arbitration for disputes involving Chinese and Portuguese-speaking countries. Macau government internally has, for example, granted tax benefits in respect of lease agreements, provided that the parties choose arbitration to resolve any disputes arising from the contract. There are other matters that are mandatorily resolved through arbitration. So I think that if the government continues to promote Macau as an arbitration center and give incentives for the parties to choose arbitration in their contracts, Macau will proceed in this way to become a center of arbitration. Finally, I cannot fail to mention the recently created Lusophone Arbitration Mediation Association, which has been making a great deal of efforts to promote Macau potential as an international arbitration center in Portuguese-speaking countries and also in China. In conclusion, as an arbitrator enthusiast, I can only hope that Macau's position as an international arbitration center, particularly in relation to disputes between China and Portuguese-speaking countries, a niche in which I believe Macau has a distinctive advantage, comes out from the paper and from the field of intentions and becomes a reality. And maybe ICC can give a help on that. Thank you.
Thank you, Mariana. These are the steps how to put Macau in the map and also the ICC map. Last but not least, Fatima, we have you on a few words from a client's perspective. The floor is yours.
Hi, everyone. It's a great pleasure to be here. Actually, I'm also I was a proud summer trainee of CNC lawyers. Some years ago, it was not in my introduction yet, but a proud summer trainee. Anyway, so I have been tasked with talking about, from a client perspective, the factors that we would take into consideration when choosing an arbitration institution. I think after this presentation, the answer is quite obvious, right? ICC, just kidding. Oh, could be, obviously, but I'm gonna still go through the factors. So of course, so some bullet points here. I would say 10 factors, probably for Macau, one additional one. The first one, obviously, it has to be reputation and credibility of the institution. For all the in-house counsel that are in this conference here, frequently we get calls from our business team asking, why fix it if it's not broken? So if we have a good experience, with an arbitral institution, we tend to stick to it usually. And of course, within reputation and credibility, efficiency is also part of the consideration. I was like really impressed when Winnie and Anna were explaining that there's also actually reduction on the arbitrations fees when there's delay. I hope my boss is not watching this. Can you imagine if like there's salary cut when there's a delay on my part? It's not working well for me. So definitely efficiency is a key consideration, especially well, us litigators are much less likable than we thought we may think of ourselves. Frequently, business team will be like, okay, we have so many ongoing projects. Why are you calling me about something that has happened like years ago? Probably, team members are not around anymore. They might have, left the company, or worst case scenarios, they might have passed. So definitely time is of essence, because well, business teams, they want to work on current projects and not the past. And frequently with litigation, arbitration would deal with the past. So having an efficient arbitral institution is definitely one of the key considerations. And other thing is enforceability of awards. If the institution has a good track record on enforceability, that's also one of it. Well, it's of course is an additional, it's a bonus point. And then the second factor would be the rules and procedures that the institution would use. As Mariana was saying, normally it's international arbitration institutions. I mean, the rules tend to be quite comparable and up to international standards. And then the third factor would be neutrality and location. Well, neutrality is like a given, right? If we choose arbitration, well, we want this institution to be neutral, fair, take good consideration of due process. Location is basically we tend to choose a place that is closer to us. We wouldn't want to spend expenses to fly team members or lawyers to a jurisdiction. So I mean, since we're in Macau, probably Macau institutions, Hong Kong, arbitrary institutions like Integrated Bay Area would be among our top considerations. And then the fourth thing is about experience and quality of arbitrators. We also want, because basically some arbitration institutions have like a closed list of arbitrators. Like others, like ICC, you could basically select anyone you want, right? So if we are to choose if we need to choose that particular arbitration institutions due to other factors, then having a good panel of arbitrators could be one of our considerations as well. The fifth factor would be cost and efficiency. So again, for business teams, like dollar sign. If it's cheaper, then why not that one? And then and interestingly, Winnie was commenting that Anna's doing her work for free, right?
Yeah.
Business team once told me that if it's free, we take it. So, another thing, like if there's like added service, why not? The sixth factor would be administrative support and facilities. This seems to be like quite a basic requirement, but sometimes we do look into that because we did have I as a lawyer had experience in the past where the client wanted to just participate in the hearing as an observer, and during COVID times this person could not come in. And then basically, that arbitration institution did not have video conferencing working that well. So it was just like things like this do matter. Nowadays it seems to be given, but having a good infrastructure or even hardware would also be definitely a plus. And then the seventh factor would be the level of institutional involvement. As Winnie and Anna they explained, ICC did have quite a high level of scrutiny of the awards. while there are institutions that have much less scrutiny. So also it depends on the appetite of the client, right? Do we want a high scrutiny, or just or we just want to have just trust the arbitrators that they would do a good job. Eighth factor would be special features, innovations. Do the arbitral institution have features like emergency arbitrations, expedited procedures, or even online case management, which is quite common nowadays. I also wanted to know if ICC have this, but anyway, you can let me know later. And probably mediation, arbitration, ARP-MED combination, things like this could also be useful in certain types of cases. Then the ninth factor would be privacy and confidentiality. Do we want our cases to be public at all? Because some arbitration institutions would redact, the awards and publish them. Do we want that, or we want to keep? But even those institutions, we could choose. We could say expressly that we want our award to be confidential. But anyway, if you have that in mind, then probably you would also want to take into consideration the issue of privacy and confidentiality. Then the 10th factor would be language, culture considerations. Do we is the institution ready, for instance, to work with Portuguese or Chinese documents? These are the two official languages of Macau, right? If we do we want to translate everything into English, or if the arbitrators and even the institution would be ready to work with these languages? Probably we would also want to take into account if in that particular cases we have a lot of documents written in language that is not English. And then the last one, the 11th one, is Macau specific. So Mariana just mentioned this 50% discount for grant of use and leasing agreements. But for us to benefit from that discount, you would need to choose one of the two Macau arbitral institutions, in the arbitration clause. If we want to benefit from that, it's a huge discount. It's good, right? 50%. Then we have to choose one of these two institutions. So this is like a Macau specific factor.
So it's very interesting to see, and as we finish this panel, kind of tying the several issues that were discussed, right? So at the beginning, we had a presentation on what is the ICC, what is this ICC arbitration specifically, the history, the structure of the court, its procedures, some practical questions that we anticipated for us, but also a discussion of the benefits and the specific characteristics of ICC. It's a hands-on procedure. There is some cost control. And award scrutiny, which is the bulk or one part of the most important part of the work that ICC Court does, as I was able also to complement. Not only that, we also addressed, and a lot for everyone's benefit, but also for Winnie's benefit, and the ICC's benefit, Macau's legislative framework, some gaps that the arbitration law came to fill, some data available, and also what is the space for improvement within our community and how we can continue to promote and develop arbitration in Macau as we take it forward and consolidate it here. Not only that, but also our last point on what are the elements that clients actually choose when they choose ICC arbitration. And this includes a plethora of issues, but I highlight, of course, credibility, efficiency, enforceability, which is truly one of the key factors, I believe, proximity, quality of arbitrators, infrastructure, but also this language and culture that ties in with proximity. And so, of course, it's an honor for me to be the first member appointed for Macau for the ICC Court. I'm able to accompany proceedings not only in Portuguese and Spanish. They ask us there are a lot of Brazilian cases, so they ask a lot of our help to a lot of the Portuguese-speaking members of the courts to stampede on those, but also a lot of other that take place in English and all over the world. So it has been truly a pleasure and an honor to step this and to advertise also for Macau in this role. So I truly believe it is part of my role to also bring ICC to Macau and enable all the local practitioners, business, academics, all those that are somewhat involved or interested in an arbitration to also learn about ICC, because it is the leading institution in the world. And so bringing these two two elements in touch, I believe can truly be beneficial for everyone that is interested in arbitration. So in sum, I hope, we all hope that this initiative served its purpose in promoting this dialogue that we're starting between ICC and the Macau legal community more broadly, that promotes the aspects of our legal community that are the most relevant, which include multilingual, multi-qualified professionals, a pool of talented experts in different areas of law that have the potential to appear in arbitrations in ICC, not also as counsel, but also as arbitrators. And in order for that to happen, the ICC has to know that we exist, that these lawyers have these capacities, and that these parties have this interest in ICC arbitration. So I thank my panelists that accepted this very challenge to be here today and to speak to all of you in the name of arbitration and Macau practitioners. And I invite everyone now to ask your questions directly to us, including to Winnie, that came all the way from Hong Kong, that may help you answer those questions, and that may, of course, benefit from knowing you and knowing more about your profiles. Having said that, I also finally thank our host again for having us here. And in a nutshell, muito obrigada a todos pela vossa presença. Thank you so much for coming. I believe that's it. I think we're done.
Ayana, thank you so much. João Moreira at the University of Macau. Thank you so much for all the panelists. Actually, I want to actually ask on something that both you and Winnie have touched upon, which is the intervention of the ICC at several levels. Could you talk a little bit I understand that there's like 3 levels where the ICC might revise the work by the arbitral tribunal. Can you talk a little bit about what's been like, I don't know if you have any statistics, but the number of times where an arbitral tribunal has been, how often does an arbitral tribunal is asked to revise their award? What is the sort of comments that you've mentioned a few, but which ones have appeared more often? Which are the cases where you've really had some trouble? So if you and Winnie could perhaps illustrate exactly how the court and how the Secretariat has intervened, I would be very curious to actually have a closer view on that. Thank you so much.
Maybe if we'll collect up to 2 more questions and then we'll close. I wonder if anyone has another question, and then we'll go from there. Okay.
Hi, good afternoon. Thank you very much for the brilliant presentation that all of you have given to us. I'm Teresa Leung. I used to be a judge, and I'm really interested in arbitration. And I'm really puzzled following the question raised by João regarding the scrutiny that the ICC court has over the awards. I assume that the scrutiny focuses only on the final award, but also throughout the whole procedure, as Anna has said about, I think it was Winnie that talked about these scrutiny on the various phases of the arbitration. So the scrutiny to me is not something new, but it's something that puzzles me, because as a judge, I don't feel any constraint regarding the award or the decisions that I used to give. So when I heard about this kind of scrutiny, it really struck me, because I wouldn't accept that anybody gives me an idea how I should decide. So my question is, what are the levels of intervention of the scrutiny, whether it's only on the formal aspect of the areas regarding the procedure, whether the arbitrator has forgotten something important to address, or even go into the merits? And when it is the case, how far can the court go in order to ensure that the award can be enforced, has nothing, any problem that forbid the award can be enforced wherever it has to be? Thank you.
One last question we'll take. No? I think, okay, we have two. Okay, one last question over here.
Hello, Anna. Hello, Winnie, and all the speakers. I'm Alfie, a student of the University of Macau. So after the presentation of Dr. Mariana and Dr. Fatima, we understand that Macau is trying to place itself as an arbitration, to improve itself in the arbitration side, not only on the GBA, the Greater Bay Area side, but also trying to place itself as the center for resolving dispute between China and the Lusophone countries. So my question to Winnie and Anna is, does the ICC actually have received cases between these two sides, or like I want to see if Macau is aiming for something that isn't there yet? Yes.
Thank you so much. I think we had one very last question.
I think it's not very relevant or significant. I just was reminded from experience I had in arbitration hearings that it is actually very important to have proper premises to conduct the hearings, because in arbitration sometimes you have busloads full of boxes, you have hundreds of witnesses, and my question was whether the ICC, being more hands-on institution, if they also provide premises for the hearing.
Sure, I think we can start with that last question. Winnie, what would you say to Julia about this issue of arbitration hearing centers and premises?
So the ICC in Hong Kong doesn't have a venue for the arbitration itself. But we see that in cases, parties will, it really depends on the parties. Some parties prefer to have it in the hotel. Some parties prefer having it at the HAIC as well. And then some parties, we do have a venue provided by the Department of Justice, because the ICC is a part of the legal hub. It's provided for free. So any arbitration cases submitted to Hong Kong, which is administered by the Hong Kong offices, can benefit from the free hearing venue provided by the Department of Justice.
Yeah, let me add, in my experience with ICC cases in Europe, it depends. We also rent hotels. You can also, in big firms that have big rooms, it is not unusual that hearings also take place in big rooms. In Paris, for example, there are several hearing centers. One of the ICC, that's brand new actually, that the parties can also rent and use for those purposes. So you have, in different cities, there are different ways in which that kind of logistical nightmare sometimes can be arranged. But it really may depend. But here in Hong Kong, we have those options. Perfect. Then I'm going to reverse. So we're going to reverse the order of the questions. So the third question we had was about Macau as a seat center of arbitration and the ICC's experience on this. Winnie, I give you the hot potato here again.
Yes. There is a very huge case, which is seated in Macau, which is, I can't actually say it publicly because it's all over GAR as well. It's a casino case, which related to having a casino in Laos. It's still ongoing. I mean, the arbitration actually finishes. They try to enforce the award in Laos, which is the enforcement proceeding is still ongoing, and then there is still subject to appeal. But that case is actually administered by the Hong Kong office and personally by me as well. So our neck is actually on the line as well. But we have been following very closely on that case, and then we have been reading on the enforcement procedure in Laos as well. And then we understand that it's the reasoning for the first instance for enforcement is that because Laos court has already decided on the issue. That's why they decided not to enforce the arbitration awards. So we are still keeping a very close eye on it, but then it's a very huge arbitration. It's seated in Macau, and it's also under Macau law as well.
Yeah. I'll add there for the connection between China and the Lusophone countries. In my legal practitioner hat, I've come across one contract between a Chinese party and a Portuguese party where the seat was Macau. There was some negotiation between the parties, but the Chinese party did not budge and insisted on Macau as a seat. So at least in my experience, I have witnessed this once. I don't know if there were later developments on that, but just to assist. I don't know in your case if you have seen any connection between Lusophone and Chinese parties in your work.
Not yet.
In ICC cases, I've seen a few Portuguese-speaking parties and Chinese-speaking parties facing each other, but not seated in Macau. So in other cases, seated in other cities. So the disputes are there. You just need to catch them. I think the first two questions are actually very much intertwined. So it has to do with the measure and the limits of court scrutiny. One of the first sub-questions were if there were any numbers or data on how many decisions, or I'm speaking here of words, are approved or not approved. I don't think there are any statistics on this.
There is, but then it's publicly available as well. But then I don't have it for everyone today. So if you're interested, it's published online, so you can check our statistics for 2023.
Yeah, in my anecdotal experience in the last year, there are very few cases where the court doesn't approve an award, and it only happens when the document is not readable. I mean, it doesn't make sense, or a section is very odd, it's incoherent to a point where you cannot make sense of a document. So it's really, really very, very exceptional. And coming now into the boundaries of the scrutiny process, the Tratezalong is a judge and has years of experience in rendering awards. That may not be the case with all the arbitrators that you see. Right, so there may be different levels of experience, and the experience with different applicable laws as well, and with different parties that may or may not be more combative and more aggressive in the proceedings. So, so you have a very diverse, I think, group of proceedings in ICC arbitration, and so the purpose of scrutiny is to promote enforceability, which means that the revision is the scrutiny process, the comments we make, which are suggestions, I highlight. We don't change the award, we make comments for the Secretariat to provide the arbitrators. And they're focused on formal aspects. So we do not review the merit, we do not touch the solutions that the arbitrators conclude, we do not touch the legal conclusions. We cannot give an opinion on whether or not I believe this was the correct decision or not. This is absolutely off hands. So the scrutiny is focused on formal aspects. Do we read the award? Is all the procedural history there? Are all the details there? There's this explanation. Okay, the tribunal reached this conclusion, but I don't really understand based on what evidence. Maybe the tribunal can expand here a little bit more. Little suggestions that may make sense once you read the whole decision. So I think the level of interference is complementary. It's additional to, I think, what the award already provides, if that makes any sense. All the suggestions we make are suggestions, so the tribunal can decide to adopt them or not. I think it's completely within the tribunal's discretion on that point. And of course, this is for the final award. I think that the other document that's relevant in the proceedings that we touch is the terms of reference, which is right at the beginning. I think there the purpose is to make sure that the terms of reference reflect the rules, because the ICC rules have specific requirements of what has to be in the terms of reference. So our analysis is based on the application of the rules, the correct application of the rules, if I'm not mistaken. So the scrutiny process has very clear boundaries, I believe, that the court can provide. And if I may say, I think in terms of examples of things, I think so I mentioned some. So if we feel like legal basis is lacking, we can make a comment, ask for the tribunal to clarify that. Or if, for example, in a dissenting opinion, there's an argument that we don't see in the majority opinion, we may ask the tribunal, arbitral tribunal may consider addressing this issue that we see in the dissenting, for example, because we don't have the history of the case, so we don't know what the deliberations were, we don't have access to that. So it all is based on what we see before us and trying to make sure that nothing is inconsistent or incoherent. I believe this is my answer to the questions. I don't know, Winnie, if there's anything you'd like to add.
As to the procedure, I can actually give some examples of what we actually will raise a red flag to the arbitrators. A very common example is where there is a non-participating party, non-participating respondents. Under the ICC rules, the arbitrator needs to decide on jurisdiction. So that is something that is often forgotten by the arbitrator, and that if they don't have submissions from the parties, it's really difficult for them to write an award on this. So if we see in the procedural history, in the procedural steps, there might be some indication they might have missed out this jurisdiction. That is something that we will raise with the arbitral tribunal. Also in a non-participating party, for example, if the tribunal only invites one party to comment and then it completely forgot the other party, that is something we will raise a red flag to as well. And also another example, for example, is security for costs. That is often a red flag because in some jurisdictions, the arbitral tribunal may not have the jurisdiction to withdraw the claims based on the parties cannot pay the costs. It's access to justice issue in some jurisdictions. So that is something that we will raise with the tribunal. And for a very general example, like Qatar, Saudi Arabia, where there is law, local law on the award, which the arbitrator has to sign on every page of the award, minor things like this, we will actually raise a red flag with the tribunal as well. So these are some of the examples that we will definitely raise with the tribunal, and then we will be watching throughout the entire process to make sure if we can identify them in the first instance, we will just raise it to the tribunal. And then we must focus that it is up to the tribunal how they take the comments, because after all, they're responsible for all the enforcement, all the set-aside issues. So it's real. So they make the final decisions on how the case will run.
Thank you so much again. I hope this was very informative.